Hi, thank you for joining us. My name is Kimberly Kay. I'm the editorial and operations director of the Legal Insurrection Foundation, and we're really excited to bring this discussion to you today. I'm very pleased to have Professor Jacobson, who is our president and founder of the Legal Insurrection Foundation, with us today. And so we're just going to spend a little time sharing our thoughts on the latest round of Supreme Court decisions. We'll also be talking about last night's debate. We have quite a few thoughts on that. Professor Jacobson in particular. So I think we're just going to go ahead and jump right in. And one of the first questions I have for you today, Bill, so we had a handful of cases that were issued this week, and we know that it's not a usual thing that they've actually pushed some into next week. We were thinking we were going to get the rest of them this week. Before we start talking about the cases themselves, do you have any thoughts about the fact that they've actually split up the decision days, pushing it into July?
Well, going into July is extraordinary. I think it happened maybe over the pandemic, but it's extremely rare. So I don't really understand why they did that. They could have easily pushed out one extra decision each day this week and they'd be done. So my speculation is that the big one, which is Trump immunity, has not been issued yet. And they might be fighting over it. They are polishing the decision. They've been particularly secretive after the abortion decision leaked. So I think that's it. I think they may be fighting over putting together a majority as to how much immunity they're going to give him. Is it going to be pretty broad, or is it going to be extremely narrow? And so my guess is there's a big fight going on, and there may be coalition building, and maybe they don't have a final split on the court yet on what they're going to do. So that's got to be why. There's no other explanation. They've had bigger cases before, and they got it done by June 30th. So I don't understand why it slipped to Monday, other than it's just a big one, and they're fighting over it.
I mean, I think that makes perfect sense. It was a little disconcerting to know that they're pushing it back out, because then you're going, what's going on that we don't know about? What's causing this to be pushed out when it's something that traditionally is taken care of, like you said, regardless of how big the decision is. It's not something they usually push off until later in the summer. So to the cases themselves, let's start first with the decision concerning free speech and social media. I think it might be helpful to give, if you can, just a very brief overview of the tenets of the case, what the decision was, and then, what that means. What is the impact? Does it affect us on a daily basis? If it doesn't, who does it affect? I think that would be very helpful.
Yeah, so that was the one involving states of Missouri and I think Louisiana, who were later joined by some doctors, social media people, and it mostly regarded censorship regarding COVID, not exclusively, but mostly. And they sued, they subpoenaed documents because the state attorney generals had the ability to get documents. So to start with, this is not the usual case. This is not an individual litigant who says, I think I'm being throttled on Facebook, or my number of followers have dropped on Twitter. You can't email Facebook or Twitter, now X, and say, would you please give me your communications with the government? They're not going to do it. But because the attorney generals had subpoena power, they were able to get documents and bring suit. And what they uncovered, we've talked about a million times, we've covered it on the blog many times, is they found extensive pressure campaign by government officials to get Facebook and Twitter, the so-called Twitter files, and Instagram, which is owned by Facebook, to censor commentary they did not like, again, mostly about COVID-related things, the masking requirements, the vaccines, the 6-foot rule, all those things that were dismissed as conspiracy theories and we now know have been proven to be legitimate concerns, were silenced. And they obtained the documents showing that that was under pressure from the government. That's significant legally because that turns a potential private case, which would be very difficult because the terms and conditions at these platforms allow them to do just about anything, turns a private case into a First Amendment case because it's government action if they're doing it at the government request. And that was successful in the federal district court. which issued an injunction against the government doing it. It was successful in the appeals court, which confirmed that injunction, pared it back a little bit, and basically said, government, you can't keep doing this. You can't keep pressuring these social media platforms. Supreme Court reversed, and they reversed on what's called legal standing, found that the plaintiffs did not have a claim that would entitle them to sue as to injunctive relief, so as to future relief, preventing future misconduct. Maybe they have a claim as to past conduct, that would be damages, but they could not get an injunction because they could not show various causation, boiling it down to plain English. They could not show that they were under threat of this happening to them again, and therefore they could not show that they had a claim for future relief. And that was it. Devastating ruling because of how hard it was to even bring this case. Like I said, no private citizen alone could bring this case. I know that there is somebody who has brought a case, Alex Berenson, individually, but I don't think he's seeking injunctive relief. I think he's seeking damages. And so that's where it is. It's platforms have always had, by their terms and conditions, the right to do whatever they want, pretty much immune to suit for doing whatever they want because they're private. But now we have a government that can pressure them, and there's really nothing anybody can do about it. And so that's really the harm here, is that we're left helpless against government pressure on social media platforms, which are the platforms on which everybody communicates. I mean, they're like the old telephone wires. If you can't express your view on the telephone wires because the telephone company doesn't like what you're saying, that's a problem. Now, there's other regulations for that, but my point is public debate can be stifled by the government now, and there's not a lot that you can do about it.
It's incredibly concerning, and I think part of what is most concerning, at least to me, is that this is not a situation where everyone's just speculating that, oh, they are monitoring speech, oh, they can get all of this information on you, oh, they are interfering. Probably. There's no longer a probably. We know for certain that this is something that the government is actively interfering with and then also taking action on. And so to me, that brings it to a completely different level of concern than what it was before. So I think that's something we definitely have to keep an eye on moving forward, especially in the interest of true free speech. So let's go ahead and move on. The next thing I want to ask you about, this one was just kind of a train wreck of a case all the way through, was the Idaho abortion decision case. Not only was the decision leaked online early, which, I mean, I'm not sure how it continues to happen. That it's only abortion cases, too, that are leaked early, which I don't believe in coincidence, so I don't believe that's coincidental either. But it was leaked online early. And then we have Justice Ketanji Brown talking about pregnant people as though there's anyone who could be pregnant that is not a woman with a uterus. And I'm not one to get riled up about, their splicing and dicing of words very much. But I am a mother, and I have actually been pregnant. And despite the fact that men believe they might know what it feels like, there's just no relation to that. And it's one of those things that drives me crazy that they continue to try and act as though pregnancy and the things that women deal with are somehow included with another sex when they're definitely not. And I mean, to me, it ends up turning into a reverse feminism situation where they're taking the things that our foremothers did fight for, and now they're including men, and that's not the way this works. That's not the point. But I mean, that's my rabbit trail there. But let's talk about that decision, if we can, for a few minutes, and what was at stake here, what was decided, and then, of course, your thoughts on this whole use of pregnant people, because this is one of the first times, at least as far as I'm aware, that we've seen this language in something from the Supreme Court. We've seen it in woke doctrine and legislation from state houses and all kinds of crazy places and crazy things elsewhere. But at least as far as I'm aware, it's the first time we've seen it in a Supreme Court decision.
Yeah, well, the decision itself was really fairly narrow. It's whether there would be a stay, so a halt, on an Idaho law, which, as it's described, would not even permit abortions in an emergency situation, emergency room abortions. And this is pending the rest of the lawsuit. So what the Supreme Court did is vacated the stay on that, and so that reinstated, I should say, the abortion emergency permission while it works its way through the court. So not a final decision whether a state can ban even that. But the important thing, as you say, was the dissent by Ketanji Brown Jackson. And I always pause when I say her name, because having grown up in the 70s, I want to say Jackson Brown, but it's Brown Jackson. So I literally have to pause every time I say it, Brown Jackson. And, when she wrote a dissent on the affirmative action case, I think I wrote on the website that if you want to know what critical race theory working its way into the judiciary will be, read her dissent in the affirmative action case. Because frequently I get the question, is this working its way into the law? Well, this is critical gender theory. This is diversity, equity, and inclusion verbiage. And she used the term pregnant people. And she was the only one to use it. I think it was Kagan, who wrote the majority decision, if I'm remembering correctly, used the term pregnant women. Okay, but Ketanji Brown Jackson used the term pregnant people, and it's very interesting because whenever there's a big Supreme Court decision, our inboxes get flooded because we're on lists, with announcements. And Human Rights Campaign, which started as a pro-gay marriage group and now has morphed into a transgender, gender identity sort of movement, very well funded, extremely wealthy group. I got one from them and celebrating the decision, but particularly they used the term pregnant people, that this is a victory for pregnant people. They didn't reference the dissent. That's the term they use. And that's the term she's using. And that's something that how you see this drip, how things get a foothold. Now you have a Supreme Court dissent using that term. That legitimizes it, a really ridiculous term. I mean, the term should be pregnant women, which is what all the other justices used, okay, throughout their decisions. And it's pregnant women. That's what it is, okay? And she also used the term pregnant patients, which to me is less bad because a patient who is pregnant, fine, pregnant patient.
But it's still, I mean, it's pushing the line there. Yeah.
Yeah, but pregnant people is the term of art of that movement. And that's how you see things slip in. It's now in a Supreme Court decision. I think you will start to see more and more judges throughout the system use that terminology because a Supreme Court justice has used it. And so I think that's what's significant about the case. I don't think the case is usually significant legally. It's just a temporary sort of situation. But now I can't say I haven't searched, Westlaw or, artificial intelligence, ChatGPT, whatever. I haven't searched if any Supreme Court judge has used pregnant people before. But, how long before we see birthing people? Okay. So this is how things change, that we start to adopt their terminology. And all of a sudden, by adopting that, we've actually adopted their ideology, not just their terminology. And that's what's significant there.
And it's something, I mean, this is coming from the woman who in her confirmation hearings was, unable to define what a woman was because she wasn't a biologist, which is by far one of the dumbest answers I've ever heard in my entire life. But I think you make a great point, and I think it's something we have to be very aware of and very conscientious of, that we cannot adopt language that is not accurate to what the words mean. And that's something that the left and progressives and that whole world bundle, that bundle of ideology has done, is they work to, it's absolutely intentional to pervert the meaning of words. and to use terms that work in their favor, that help to embed and implement their worldview, that help to embed their policies, their thoughts, their ideology. I think one of the best examples of that is actually in the abortion movement itself, that the pro-life movement was so successful in labeling to the point where it stuck anti-abortion, right? They decided rather than saying, just pro-life, that they would be anti-abortion, that it caused the movement to then have to rebrand and come up with other terms because they didn't want to be labeled that way. And I think, for those of you who are listening or watching that feel helpless, it's a very small thing that you can conscientiously do, is not to agree to use words that don't mean what they mean. So if the term is inaccurate, pregnant people, that it should be pregnant women, and just refuse to say pregnant people. And it's a subtle thing, though. It's a very subtle thing that they do, which is brilliant and also a little bit terrifying. But so let's move on to the January 6th decision that we saw. And same thing, if you can just tell us a little bit of background there, what was, a little bit about the decision and the ramifications of it.
Well, as we know, virtually anybody who was at the Capitol, near the Capitol, regardless if the doors were open, has been charged. I think we're over 1,000. I don't know the exact number, and have been charged for things that normally don't get charged, like parading, like being in a restricted area because the vice president was on the Capitol, and then it became technically a restricted area, but of course you couldn't have known it was restricted because you don't know who's there. Things that people normally don't get charged with. And remember, we're not talking about people who committed violence. If you committed violence, there's a whole laundry list of charges they can bring against you. This was looking for people who did not commit violence, who were expressing themselves politically at the Capitol, and who the feds sought to find a way to charge them. And one of the things they found was the Sarbanes-Oxley Act of, I think it was 2002, I might be off on the year, which really is a financial fraud act. It had to do with the collapse of Enron, because one of the things Enron did is it destroyed records and concealed records and damaged records because it knew there was a government investigation of their underlying fraud. And so Congress passed a law that said, and I'm just going to paraphrase it, that said if you interfere in an official proceeding by destroying records, et cetera, that's a federal crime, pretty serious federal crime. The government took that and charged a lot of people with interfering with an official proceeding. And these people didn't destroy records. They had nothing to do with any paperwork. And so that was brought, I believe, against hundreds of people, that charge, including Donald Trump. One of the charges in his federal indictment in D.C. is interference with an official proceeding. And so the Supreme Court ruled that the feds overly extended that law, that there is no history in the legislation or wording in the legislation that suggests it is a catch-all for any interference of any type in any official proceeding. It's in fact very specific to records destruction, basically. And that came up in the oral argument that various conservative justices pressing the government attorney on, well, does this mean if you cause a senator to be 15 seconds late for a vote, that's a felony now, a federal crime of interfering in official proceeding? What if you, in a congressional hearing, stand up and protest? That delays the hearing. Is that a crime? Things that we normally wouldn't. And so basically, the way the government used and interpreted that statute, it was limitless. Anything you did that touched upon the government in any way could be charged. And the Supreme Court said, no, that's not what it is. That's not the language of the statute. That's not the fair reading of the statute. And it's certainly not the history of the statute. That's not what was intended. And so they threw out that charge against one of the J6 defendants, who had been, I don't know if he was charged or convicted or both, but so that goes away. And so there are a lot of J6 defendants who will have to have that charge dropped. What it means for a particular person might depend on whether they have other charges against them. So if you had that, and you had parading, and you had being in a restricted area, it may have no real practical effect on you. It might give you a chance at resentencing, which would probably be fruitless because the DC district court judges have been very tough on sentencing. So I don't know what effect it will have in the real world for these defendants, but it's another example of how the government, if given power, will expand it until somebody stops them. And in this case, the Supreme Court stopped the feds from using that statute in a way it does not cover. And that's what that case was. So, very big case. It's unclear, though, what implications it will have for individual defendants.
If nothing else, though, I mean, because what we saw with and I mean, I would even argue it's a perversion of Sarbanes-Oxley, because that using it for something for which it was never intended. When I look at all of this, it reminds me of any third world country, any communist country, where you can just be walking down the street minding your own business. They can detain you and find a reason why you're guilty. Surely there is something you have done wrong. And I mean, to me, that's exactly what that is. You're grabbing something that's completely unrelated and trying to apply it to people who were just showing up to a rally on January 6th, of course. And so, at least as far as I'm concerned, I'm glad that there has been some pushback there, or at least some right decision on the fact that this is not an appropriate use of that particular regulation in order to hamstring these people who showed up to see a president speak, So that at least is, I mean, if you have to call it a win, I'm glad that was decided in the way that it was. So let's move on to the Chevron case. You want to share your thoughts on that?
So I'm going to combine that with the decision a day or two earlier regarding Securities and Exchange Commission, SEC, not the Football League.
I always have to remind myself.
Agency.
Yes.
They're somewhat related. I mean, they're not legally related, but they achieve the same result. So in the SEC case, there was a challenge to the Securities and Exchange Commission's use of administrative law judges to hold trials, internal SEC trials. This is an area in which I've practiced most of my career, and before administrative law judges who were employed by the SEC. So what you had is the SEC bringing charges against somebody to be tried by an SEC judge and prosecuted by an SEC prosecutor. And people said, well, wait a second. I have a right to a jury. If the government's going to impose a fine, these were not criminal charges. That has always gone to court. These are civil penalties and civil fines. I'm entitled to a jury under the Constitution. And you can't force me to go before your administrative law judge. And the Supreme Court said, that's right, that you have a right to a jury on these. And therefore, that's a huge blow to the administrative power of the SEC. They can still bring every single charge they previously brought, but they have to bring it in federal court where the defendant has a right to a jury. So that was a scaling back of the administrative power, which will have a lot of impact on other agencies, because I don't think the SEC is the only one that has these administrative, disciplinary, punitive sort of things. And then the court today released a case involving what's called the Chevron doctrine, which was a case in 1984, which gave deference to administrative agencies in determining the scope of their authority. So you have a statute, and a statute.
What could go wrong?
What could go wrong? That's right. It's like giving your kid authority over the scope of dessert or something like that. So what would happen is you have a statute that vests certain powers in the EPA or another agency. In this case, I think it was the Fisheries Agency. I'm not sure what entity it's under, but the Fisheries Agency passed a rule or a regulation requiring that fishing boats, and I think this was on the East Coast in New England, have somebody there to monitor what they're doing, and that has to pay as a fee for this 20% of their catch. Okay. And so these fishermen said, wait a second, you don't have the power to do that. That's not. And they said, well, yes, we do. Okay. The way we interpret the statute enabling us, we think we have the power to do this. And so the question before the Supreme Court was, will the Supreme Court do what the Chevron case in 1984 said, which is you give deference to the administrative agency's interpretation of its statutory power? And the Supreme Court said, no, you don't, that's for the courts. And they may have the power to do it. They may have the power to force you to hire somebody to go with you on your fishing boat and give them 20% of the proceeds from your catch to pay them for monitoring you that the government forced. But whether they do or they don't have the power, that's up to the courts. It's not up to the administrative agency. And so that's used. You combine the SEC case with the Chevron doctrine case, and you do have a very significant curtailing of the power of federal agencies. They're still there. They still have huge budgets. They can still make your life miserable, but their ability to expand what they're doing and their ability to levy fines on you without clear authority is severely curtailed. And that's why you have a lot of, pro-bureaucracy lawyers on X, formerly Twitter, saying this is terrible. This is the worst thing. They've gutted the state. No, they haven't gutted the administrative state. What they have done is they have brought it under the control of the judiciary, not in day-to-day running of these agencies, but in terms of their legal powers, which is what it always should have been. So, right. When the Supreme Court pulls something back to the middle, back to our traditions of separation of powers and individual rights, when they pull it back to those traditions, all of a sudden the left screams that something's been destroyed. Nothing's been destroyed. It's been restored. The power of people to get a jury trial, the power of people to not be subjected to what are arbitrary, self-imposed interpretations of administrative power has been restored. That's all that happened. We're now back to the middle. We're not any place else. But of course, everybody's screaming bloody murder, how terrible this is. But it's actually was a good week. But it's not like, I can't remember how to pronounce his name. It's not like the guy in Argentina who took the chainsaw to the bureaucracy. I mean, we need to hire him here.
We should be so lucky. We should be so lucky.
So the Supreme Court didn't take a chainsaw to the administrative state. It just stopped it from expanding even more on a whim.
And they say that like it would be a bad thing. We have such administrative bloat in this country at every single level. Even at the local school level, it seems like anytime there's new construction, they're not, extending or expanding a school. They're building another administrative building because that's exactly what we need, But yeah, anytime when I was looking at that decision and when it was talking about the fisheries industry and that whole thing, several years ago, Jim Garrity at National Review wrote a book called The Weed Agency that I highly recommend. And it really takes many, many brilliant jabs at the administrative state, the lengths that they go through to preserve themselves. And it's hilarious, but I always, because the weed agency ends up dealing with the agricultural department. Anyway, if you haven't read it, I highly recommend it. It's a quick, very entertaining read. And if you hate the administrative state as much as I do, I think, or even half as much, I think you'll enjoy it. So the last thing I want to discuss today is the debate that happened last night. And so I know we shared some of our thoughts about what we thought the candidates both should do or needed to do and what their challenges were. And y'all can find that in a previous video. But when I was listening to it last night, one of the things that occurred to me too is it's so unusual. Usually we have candidates up on stage who are vying for a spot with nothing but their promises. we have a track record of things they may have done in the past in their respective sectors, but it has never happened in my lifetime where we have two presidents who are debating one another, both who have served a term in office. So we have 4 years of each of them in which to gauge how we think they're going to do. And at least for me, I felt like the conversation, we've heard it all. We've heard the talking points. We knew what Trump was going to defend and what he was going to attack. We knew what Biden was going to harp on and the things that he would attack Trump. Of course, the Stormy Daniels stuff, all of that. They love to put him in a corner and make him explain that away, which I actually thought he did pretty well. But I think it was just a very unusual stage for that reason alone. What really surprised me, though, and what I was not expecting, was how weak Biden sounded. And I know I put that in our chat. He sounded feeble and weak. And I mean, he's definitely dealt with competency issues for arguably his entire term and even before that. Because I'm so old, I remember even in the Obama years that they would trot Joe Biden out. Inevitably, within a week or two, he would say something like completely outrageous. I think there were all kinds of Twitter accounts at the time, devoted to Biden's gaffes. And then they would, rush him back off to Delaware until the headlines cleared out, and they would keep him closed up until they needed him again to divert attention away from whatever else they were embroiled in. So, I mean, he's always been a loose cannon, but it wasn't even close to that. It was just how feeble and weak. And, it's not someone that I would leave my dogs with, much less an entire country. So I'm curious about your thoughts on that and what some of your takeaways were.
Yeah, I think it was pretty shocking. It was much worse than I expected, because the history of Biden in debates against Trump was they sequester him away for 4 to 5 days. He'd come out and he'd give a decent, sometimes good, sometimes decent, but he'd perform for a couple of hours. And that's what everybody expected. They sequestered him for a week this time. Everybody thought, for 2 hours between the medications and the rest and the prepping, he'd get through it. But from the beginning, he had the same blank stare that we've seen so much of, the same lack of, mental acuity, all the problems we've been writing about and noticing that the mainstream media has dismissed as cheap fakes, that, clips out of context. You cut him off. You didn't show who he was talking to. You're saying there's nothing fake about these. This is just who he was. It all came out. It could not be hidden in 90 minutes on TV. It just was a live stream, and it was painful. And from the beginning, and the Democrats began to panic. So Joe Biden came across as old. He came across as out of it. He came across as not cognitively sharp. He came across as everything the Trump campaign has been saying about him was verified. And that's why I think it was so devastating. It's not like, oh, Joe is sharp. Oh, he had a bad night. No, this confirmed what I saw some people refer to as the right-wing caricature of Joe Biden. Well, it wasn't a caricature. When it's accurate, just because it's negative doesn't make it a caricature. It was
right,
accurate.
Doesn't mean it's wrong.
And if you want to know how bad it was, watch the clips, and we've posted a lot of them on the website, of CNN and MSNBC afterwards. They were apoplectic. They were more brutal than any right-wing commenter. They're talking about how their phones have been blowing up with Democrats who say, we got to change. We can't do this anymore. Van Jones, in kind of Van Jones style on CNN. I love this guy. Joe Biden is a good man, but tonight was not good. We need to rethink what we're doing. Others were more blunt. And so I think that it really was a shakeup of the race. It'll be interesting. A lot of people say, well, debates mean nothing. Debates don't change anything. I'm not so sure that's true. I haven't seen the
Right.
numbers yet on the viewership, but you don't need to have watched it. You just need to have watched CNN or MSNBC, obviously Fox News, read the New York Times. There were four, I believe, op-eds in the New York Times from regular columnists, including Nick Kristof, saying Biden has to go, that we can't do this. And they're not doing it because they care about Joe Biden. They're not doing it
Right.
really for any other reason. They're afraid Trump's going to win. Okay? And Trump was sharp. Give the guy credit. I think the format, unexpectedly, I think we accepted the prevailing wisdom that the format of, mics being turned off when the other person is speaking, no audience, really no interactions, that was going to hamper Trump because we know Trump from the Hillary debates. He kind of stalked her on the stage.
Mm.
It was a real great drama. I think it worked to his advantage here. I
I do
think that
too. Yes, I
you know
completely agree. And I think, I'm sorry, go ahead and finish and then
no,
I'll
that's
jump in.
that's it. And I think it worked to his advantage. He made his points. Obviously, with anything, including when I give a speech, there's always something you wish you had said. But he was
Right.
very sure. Trump was good. Trump was the Trump people love without the negatives of talking over somebody or
Yes.
stalking them. I mean, it
And
really,
that's,
it was
yes.
good.
And that's one of the things I know I mentioned when we discussed this last week was that I think one of the things that people who were on the fence about him needed to see is they needed to see him still being assertive, but acceptably so. Not attacking this feeble old man. And I think he was probably coached on how to handle that. And he was
Yeah,
coached very well. And I think I was concerned that, walking into this whole situation, this was basically handed to Biden on a silver platter. The terms of it, the lights, the everything was all designed to assist him in being successful. And even with all of that, putting it on CNN, like everything about it was designed to provide him a substantial handicap. And he blew it, completely blew it. So I think it's very concerning. The one thing I haven't quite teased out yet, though, is that they know this. The Democrats, whomever is making the decisions over there, ultimately the kingmakers on that side, they know that he is feeble. They know that he's weak. They know he's not going to make it. They had to know that putting him on this stage is not going to do them any favors. So, what then is the end game? What's the strategy behind here or behind all of this and the decision to, because there was so much speculation months ago that they were going to pull him and swap with another candidate because of the concerns that we're seeing playing out right now. And now there's not enough time left before November to make that happen. I'm just, on the one hand, I'm very concerned about our national security, which is something I want to ask you about next. But on the other, I'm not understanding what the strategy is there, the direction that they're going, and what they have up their sleeve that they might be planning if they're waiting until like the last moment to swap a candidate to try and shore up the base so that it's not complete disarray. I don't know, but do you have any thoughts on that?
yeah. I mean, I've seen a lot of conspiracy theories. People saying that Democratic insiders set him up, set Joe Biden up. They
I
wanted to
don't
know
believe it.
now if he. I don't believe that. I don't believe that. I think the simplest answer is probably the correct one, which is he's been doing very poorly in the polling. His numbers have been slipping. He's been very poorly in terms of likability and very poorly in terms of cognitive ability. People view him as too old and too frail. And they
Right.
felt the need not to spend the whole summer with that impression continuing to get solidified and cemented. And they felt that given his past performances, given what they knew they had done with him in the past, that they could get him through this and reverse that trend. I think that's just the answer. It was just a bad decision. I
Right.
don't think it was a conspiracy. And now they're between a rock and a hard place because what are they going to do? Uh, how are they going to replace him? He's not going anywhere. I just saw before we
Right.
just started recording this that he gave a
Mhm.
speech. He's not going anywhere. Dr.
Right.
Dr. Jill is not going anywhere. And if you saw her after this, um, you know, uh, like a cheerleader, Joe, you did great. Joe, you answered all the questions.
Mhm.
It's almost like elder abuse. Okay,
Yeah.
almost like the person living with the elderly person who's got control over them. Very, very bad. I don't know where they're going to go with this. Who they going to replace him with? If it's Kamala, then she's going to do worse. How they going to not prosecute her? Who they going? Are they going to pick a white person to replace Kamala, who's the natural heir apparent to that spot? I mean, what are they going to do? They're in a very difficult
Can't
position.
find her way out of a paper sack. Bless her heart. Or finish a sentence for other reasons, unrelated to the ones that Biden struggles with. And yeah, and I don't mean conspiracy. I'm just thinking in terms of political strategery. It's like I don't understand why they doubled down when they knew of his cognitive condition and had an opportunity to address that by making a change up before. Why they have decided to double down and keep him in when he's clearly, I didn't think he was mentally competent 4 years ago, but there's definitely been a dramatic decline in the time that he's been in office. And I think we've seen it real time despite the spin to cover it up. So, I don't know. I think it'll be interesting, especially if they have another debate, because one of the things he did say too when he affirmed that he was staying in the race was that they're still set for the September debate. So we'll just have to, we will see. It's also kind of unusual to have a primary season where we don't have a lot of presidential primary contenders. We have a current president and a former president. So we're not subjected to either the abuse or drama or entertainment, whatever you want to call it, of all of the primary debates either. So it's just a very, very unusual, very strange election season this year, at least to be observing. One of the points you made, I want to talk about an article that you wrote about the need to utilize the 25th Amendment to remove Joe Biden from office, because I think, at least it was my impression, that after watching the debate, you were not just a tiny bit concerned, but you were a lot bit concerned and have called for Republicans, Democrats, everyone to invoke the 25th Amendment and to do it now. Can you share a little bit about that?
Yeah, well, it's really only the Democrats who can do it. It's essentially the cabinet, right. It's the executive officers who can invoke the 25th Amendment. And the concern there is not like the concern the Democrats had with Trump. They were talked about invoking the 25th Amendment. They didn't, because they didn't have the ability. It was a Trump administration, because they didn't like the way in which Trump was able to exercise his office. Okay,
right.
That is not a 25th Amendment ground. It's whether you have the inability, whether you're disabled from exercising that, and that's really why it's different now. And this should not be a pure political posture, because if the 25th Amendment is invoked to remove Joe Biden, it's simply another Democrat who's going to fulfill the presidency. In fact, it would be Kamala Harris under the Constitution. So we're not talking about putting a Republican in instead of a Democrat. We're talking about putting another Democrat. So the concern should not be political. The concern to me is watching him up there. And nothing, again, we didn't know before, but now it was on display, is very scary. There are scenarios in which a president of the United States has to make decisions as to our national security in a split second, in minutes. I don't, thank God we're not in the situation we were, during the Cold War, when we're all wondering, when are the Soviets going to launch their missiles? But we're not that far behind it. When is North Korea going to launch a missile? When is Iran? When is China? When is Russia? And the countdown time from when our, satellites pick up the rocket taking off, in Siberia or in China or in North Korea or in Iran, to the time it arrives in the U.S. is minutes. It's minutes. And if it's a sub-based launch, it's less than minutes or very few minutes. And we might have a president who is confronted by the military saying, here's what we have. You're the commander in chief. Only you can make the decision. And do you really want the guy who was on that stage for an hour and a half in that position, forget whether you like his policies or you don't like his policies.
Right.
They would be greeted with that blank stare that we now saw for an hour and a half. Uh, the computer's not working at home. The lights are on, but the computer's not working. It's scary. And I think that we have a very serious national security threat, that decisions that the commander-in-chief needs to make, sometimes on extremely short notice, we have someone who is not cognitively capable of making them. Kamala Harris, I think she's a fool. I think she's a non-serious person, but she has the cognitive ability to do it. Whether she'd make the right decision is a different story. But making the right decision or the wrong decision is not a 25th Amendment issue. It's whether you really have even the ability to make the rational decision. And I don't believe that Joe Biden does. And I think we are in a very dangerous position. And what I wrote is, if I were China, I'd be looking at those plans to invade Taiwan very soon. If I were Iran, I'd be looking for my nuclear breakout while we have this feeble-minded person leading the United States. If I were Putin, I'd be looking over the list of old Soviet satellite states in Eastern Europe and Central Asia and wondering which of them can I pick up while Joe Biden is, cognitively impaired. So I think this is a very scary time. And so I'm calling on it's not the Congress, it's the procedures under the 25th Amendment of essentially the cabinet and the vice president to remove him. Kamala Harris will be the president. That brings no joy to my heart, believe me. But I do believe she has the cognitive ability to make a decision. I'm not confident Joe Biden does. And I think that's too great a threat for us to go 7 more months with him as commander-in-chief. And I think Democrats may serve their purpose also in terms of getting a better candidate in for them. So we have this weird circumstance where there's a confluence of interest. I assume the Trump team loves having him there. They want to run against him. Sure. And so this is something where Democrats have to put country first, have to put America first, and have to remove a disabled candidate from the presidency.
And have to own the fact that is their candidate too. I mean, looking at it on a, politically, not just in terms of right decision. No, and I think that's a great point all the way around. And I think it's very unfortunate that at least during my lifetime, there's always been differences. Of course, like, we survived a civil war as a nation. So I always have to chuckle when people talk about how the nation has never been more divided. I'm going, well, we did fight a war. So I'm not sure that's accurate. But just the dichotomy that we've been split into, where things have to be Democrat or Republican or left or right, has really disallowed discussion. And I don't even want to say in the middle. I would just say practical discussion, right? Just like you were talking about. You have someone, all politics aside, who's not capable, competent to make very important decisions. That should be addressed without any political label, without political, ramifications being even part of the discussion. And unfortunately, that's not a discussion that's happening really outside of here, at least so far as I know, or at least it's not being broadcast en masse. So, which is part of why we're excited to do this. So just in closing, we're headed into next week where we will have Independence Day. I know we're really excited about that around here. We love fireworks and we love all of the festivities that come with that. Is there anything you're excited about for Independence Day? Any big barbecuing?
Well, nothing so much about Independence Day, but I am waiting for the Supreme Court to decide on Trump's immunity, presidential immunity, on Monday, which will be generate fireworks if they grant him any level of immunity.
For sure.
If they grant, and I don't think it's going to happen, grant him the equivalent immunity that he can shoot somebody in the middle of Fifth Avenue, like he said during his first campaign, and his supporters would still support him. If they grant him any significant level of immunity, you'll see more fireworks. So that's what I'm looking forward to.
Yeah, I think it's very interesting. It's a different season, like I said, because we don't have all of the debates. We don't have all of the stuff that we usually have on both sides of the aisle, but it's definitely no less interesting because of that. So, and I think that's all we have for this week. So thank you for tuning in. And we look forward to bringing another discussion to you next week.